exactly, and lasting impact of the international legal framework, so that we very not obey, not deny, but we obey that the Dutch colonial area and influences in Indonesia still running in our law enforcement now. And the third point, legal system, we talk about the post-independence, because Indonesia follow independence in 1945. Indonesia embarked on the task of building legal system, wrote in its own identity. We call that Pancasila. Pancasila is the only one. There's no in the world that there's a Pancasila. Of course, different between Indonesia with the Germany and Taiwan exactly. Our founding fathers declare Pancasila is the best on our ideology. So every Indonesian, every legal system must based on the Pancasila. That's I say, Pancasila Pancasila accommodate the religion. Pancasila accommodate all the tradition. Pancasila try to accommodate the civil law, religion law, and cultural law exactly. And after that, after independence of Indonesia, around 1998, there is a reformation era, and Indonesian legal system amendment of the constitution. We know that in our history, we ever implement constitution of Indonesian strict constitutional, and we back to the UUD 45, or we call Constitution 1945, and it's implementing until now. And now we are in democratic area, reformation area. Indonesia still on Constitution 1945, even though recent years there are several ideas, there are several aspirations to change to amendment of constitution, but this is still running because of course we are still waiting for the political will of politician, in this case the president and legislative member of Indonesia. And also we talk about the source of law in Indonesia. I try to divide into 4 perspectives. The first is about the constitution. The 1945 constitution forms the foundation of the legal system. It outlines, including the fundamental rights, the power of the government, and the principle of government.
Telah mengikuti
The fundamental right of Indonesia.
Ini nilaiku 112 aku tiap
Constitution that mentioned in our constitution strictly since amendment 1998, and the power of the government, it tried to be separate between legislative member, executive, and the judicial power. And also we have independence power like Commission Corruption of Indonesia, and we also emphasize that we are in distribution of power. There is a central government and there is a regional government. We call autonomy of regional government. And the second point is about legislation. In our hierarchy, there's Pancasila, Constitution, 1945, Acts, Ordinary, and Regulations enacted by the legislative branch are a key source of law. They provide specific rules and guidelines for various aspects of society. I want to say that the legal system, especially about the legislation, Indonesia give the authority to the executive branch and the legislative branch to make the regulation, to make act together. So especially in about the legislation, legislative branch can make the regulation, and executive branch also can make regulation, and the regulation must do it together. And the third point is about the judicial president. Indonesia doesn't have a formal system of state decision. Decision by the Supreme Court and constitutional courts are often considered persuasive authority and can influence the future of rally. Recently, we have a big problem about constitutional court exactly. The constitutional court tried to make the new rule, the new article, while as theoretical of Indonesian or in our faculty exactly, Supreme Court and Constitutional Court in position a passive legislation, not in active legislation. That same with the legislative branch and executive branch that have authority to make the position is the active legislation. Supreme Court and Constitutional Court is on passive legislation, but recently we know in president election we can see the situation how the Constitutional Court make the new formulation, new article of requirement to be president or vice of president. And the fourth point is religious law. Indonesia recognize Islamic law, customary law, and other religions principle, particularly in personal and family matters. Indonesian legal system, like I said before, is not the religion state, but in implementing where there is a problem. Sometimes our society resolve the dispute by using the Islamic law, customary law, and other way. So that's why Indonesia, because of its not secular state, the religion law still implemented in several places in Indonesia. For example, we have a province like in Bali. They are very obey to the customary law, because the customary law and religion law in Bali is very near, very close. It same happened in province of Aceh. In province of Aceh, the regional government and our society implement the Islamic law because of most of the population are Muslim. So that's also one of the how to say a problem. We can say it's problem, and we can say also it's not problem. If we go to Aceh, the society of Aceh say that's a good thing because we have to obey to the Islamic law. But if we see Aceh province from the national perspective, it will become a problem. So that's the reality of the law. And next is about the structure of government and branch of power. Maybe several opinion and theoretical always say in university how the Montesquieu try to make a theory about the three political power: executive branch, legislative branch, and judicial branch. It's same also in Indonesia, that there's an executive, legislative, and judicial branch. But one point that maybe different with the other country, we implement the decentralization. The decentralization about the government, regional government, get authority from the central government, and the regional government can do anything about how to build the regional, how to create the welfare to the society, but the authority is very limited. And because we are not in a state like in America, maybe Indonesia is a United States. The authority distribute from the central to the regional government. And about the judicial system, we know that Indonesia has a court, legal process, and judge. Indonesian judicial system comprises various levels of courts, including the Supreme Court, as high courts, district courts. These courts are responsible for resolving the legal dispute and upholding to the law. And also, we have the Constitutional Court that have a different authority with the Supreme Court. For example, if we talk about the Constitutional Court, it has authority to resolve the dispute of president election or general election. That's one of the authority. And about the legal process, involve various stages, including filing a lawsuit, pre-trial proceeding, appeals. Indonesia is based on a civil law system with written laws as the primary source of authority. In Indonesia, for the recent years, we find there are several theories, and we call progressive theory, that put the justice and beneficial as the first point. And legal certainty is not really strict to be implemented, depend on the situation. Even though the written laws is primary source of authority, like police and lawyer and judge and so on and so forth. That's a new discussion of Indonesia about the how to implementing the law. We want to get a justice. We want to get beneficial, and we want to implement the legal certainty. The 3 points is become debatable until now. And about the judge play a crucial role in the judicial system. They are responsible for proceeding over trials, interpreting the law, and adhering to the judgment. I want to say that the judge in our in Indonesian legal system has the big authority to dispute, to resolve the dispute of society. And until now, the judge, yeah, we can say like God, or like the how to say the ruler, and so on and so far, because the judge, the authority from the low level until the high level, they have authority to give result to all the dispute. And civil law, we can see about the scope. Civil law in Indonesia regulates private relationship between individual, organization, and state. This includes property right, contract, family law, and inheritance law. For example, if there's a problem between man to man, there's a civil law system about property. Sometimes they use national law, and sometimes also they use the religion law, or specifically Islamic law, and sometimes also they are resolve their problem by using customary law. That's the fact of Indonesian legal system now, because not all our province has the position, access, justice, and others. And about the main source are the civil codes, commercial code, and other subsidiary legislation, Islamic law in place, and a personal matter for Muslim. Until now, if we talk about the commercial law, Indonesia legal system as accommodates the international system and about the contract between state and state government to government and personal to the personal. It's happened now. And about the impact, this system provide predictability and consistency in legal application. However, it can also be rigid and difficult to adapt to change the circumstance. I want to say that Indonesian legal system face the very crowded system because there's a national rule, we have a customary rule, and there's international interaction that bring the new law to our society. That's the impact our legal system now. And also about the criminal law, there's offense and sanction. Maybe it's happened with the other country maybe. And Indonesia, if we see our prison, yeah, sometimes our prison, they have a full of offenders of criminal, and we don't know what happened, but theoretically, like Lauren Friedman say about the cultures, about the substance of structural perspective, for example, maybe our society still sometimes do crime, and so until our prison is full of offenders, it still happen now. And about law enforcement, the Indonesian National Police offers criminal law with the jurisdiction over investigation, arrest, prosecution, Attorney General Office over application. And we have correctional system. The Indonesian correctional system include prison, like I said before, and detention center with over focus and rehabilitation and for offenders. I want to say that sometimes if there is a criminal happen in our country, we try to resolve the problem by using restorative justice. I mean, the legal system we put side and try to over the restorative justice between men or to the doer of the crime. Sometimes it's happened now, and I don't know, maybe it will happen to the future, and let's see how the legal system of Indonesia. And about constitutional law, foundation of the state, constitutional law system defines the structure and function of the Indonesian state. It outlines the powers and responsibility of the government, including the legislature, executive, and judiciary. It established fundamental rights and freedom for citizens, such as freedom of speech, religion, and assembly. Maybe it's same with the other country, like legislature member, executive member, they are elected by the general election that happen in once in 5 years. It happened. We just did it for several months ago. Beside the legislature, executive, and judiciary, that's happened in central and province, and it also happened in outside the regency in our Indonesia. So there are many members of legislative in Indonesia, but specialist to the judiciary, that's the hierarchy is a vertical from the central to the local. Next, beside that, constitutional law, we have also administrative law. The regulation, administrative law governs the action government body, setting the rules of their operation and ensuring accountability. In legal form, establish procedure and administration, providing legal resource for individual offered by government action. Our legal system prepare the solution if there is dispute between the government with the society. We have administrative law. We have administrative courts that has authority to resolve the dispute between the government and the society. For example, if the central government, the executive or regional executive make decision, but the decision will the problem or break the right to the society can do the resolve by doing something to the administrative court. And family law, we can see about the marriage, like I say before. Special thing about the marriage in Indonesia, we can say strike about the marriage law. Family law in Indonesia govern marriage, divorce, and other aspects related to family unity. For example, if there is our society want to get married, of course, they have to obey the rule, the marriage system. And in the marriage system, there are several society, like province in Lombok, for example. They have more obey to the customary law between the national law, because the customary law is implemented in our home or their daily activity. So about the marriage law in Indonesia, we implement three legal system: religion legal system, and customary legal system, and also the national legal system, and including also the family law, inheritance, child custody, and adoption. And about law enforcement, Indonesia has various law enforcement agency, including the police, military, and special agency. They play a crucial role in enforcing laws and maintaining the order. For example, if the military do crime, we have the military court. They special judge how the problem that the doer from the military members. So they are going to resolve the problem by military court, and the position about the police and other court in Indonesia. And about the judicial system, the judicial system is responsible for adjudicating the legal dispute and ensuring the justice. Court at various level hear cases and issue ruling, because our ideology, like in this case Pancasila, must how to say, get justice to the society. That's the main point. Written constitution, written in Pancasila about the justice. Now the legal certainty, but the main point is justice must come to the society. And correctional system and community involvement, you can see there's a prison and other facilities in Indonesia, even though the members of prisons day by day still, the offenders more happen in the world. I don't know why, maybe because of situation, or maybe because of the awareness, or maybe because of other thing, because of economical or other, we cannot, there are several background why they do a crime and exactly. And as the country, or I want to say every country has the legal reform, because legal system is a dynamic thing. That's the legal system is not striking that not move to other time to time, but the legal system is always in reform formulation. So that's why Indonesia tried to modernization of law. Indonesia has undertaken significant legal reforms to enhance efficiency, transparency, accessibility. This form aimed to align the legal system with contemporary needs and global standard, because Indonesia is including one of the how to say international societies, and of course the society, the law must be modernized and strengthening to the law. The reform of prioritized upholding the rule of law, ensuring equal justice and protecting fundamental rights. This is happen even though in several things is still running, even though in several things still we cannot find, for example, about the protecting of fundamental rights. Sometimes we see the limitation of society to assembly. We call here FPI, from Pembela Islam, Islamic how to say special organization that refer to Islamic ideology. Now its right is limited or it's over. And also judicial independence, effort are going to enhance the judicial independence and ensure the integrity of the legal system. Of course, this maybe happen to all the country in the world. And also about the challenge and legal issue, it's happened to the every country maybe in the world. Like Indonesia, for example, maybe in German, for example, about the marriage same sex, for example, Indonesia is very prohibited for that. And yeah, of course, that's also there are several societies that do it in by secret, not openly. They do marriage with the same sex and so far. And about the corruption and impunity, this is also a big problem. And I think every state maybe, or we still find the corruption in other country or Indonesia exactly still happen. And it comes from the legislative member, executive member, and sometimes also it happen or did by the judiciary members. And technology advancement, we cannot deny the technological now is very fast to improve in our country. Artificial intelligence, we don't have a, until now Indonesians still try to find how to face the artificial intelligence, come to the society, comes to the public society, public area in the legislative, in election, or in private law and trade law and so on. And so far it will happen because artificial intelligence, we cannot deny, because it's happened and we must face the situation. So in Indonesia, we try to open the civil participation. The civil participation start when our legislative and executive members want to make the regulation. The society have right to give the idea, give to the critical to the legislative and executive member. So it's very open in Indonesian legal system to society to participate in legal system in making the regulation. And also about the public awareness. This is the big problem because the awareness, sometimes the society, they have no awareness to participate to make to making the regulation, to participating in implementing of government and others. Of course, there's collaboration. There's collaboration between legislative, executive, judiciary when the implementing of the law, and NGO also, stakeholder, and they have authority, they have right to collaborate with the government when the law is implementing. And last is about the advocacy. And about the harmonization of national and regional law, it's happened now because central government and regional government, they have authority to make the regulation. There's a regional law and national law. This must be harmonized. When the regional government want to make the regulation, must consultate that draft to the central government by using the hierarchy of government, regency, province, and central government. And about the prospect and the future of Indonesian legal system, of course, modernization and reform, it must be happen because we are international society about technology and digitalization, like we do now. This is technology and digitalization, how we can share the knowledge between the legal system in German, Taiwan, and America, and Indonesia, exactly. And of course, justice and equality. This is our hope. Every country, every society need a justice and equality from the government. And also collaboration and synergy. Collaboration and synergy among legal institution, government agency, and civil society organization is vital for successfully implementation of legal reforms. I think we know that EDEGIUM, for example, say, ubi societies EBEUs. If there are society, there is a law, and the law must closer to the society until the society, the state can get the welfare to the society and welfare to state. I think that's my short presentation about the Indonesian legal system. We can continue in the Q&A after other speaker. Thank you very much for moderator, and time is yours for Mr. Yudi. Thank you.
Okay. Thank you so much for the presentations, Bapak Irwansyah. For Q&A, actually, we just collect at the end of the presentations. So we just move to the second speakers. The second speakers will present on legal system in Taiwan and America. Will be delivered by Prof. James Su, LUSGD. He is a lecturer in Faculty of Law, UNTEC. So without further ado, Prof. James, are you there?
Yes. Can you hear?
Okay, yeah. Times and place are yours.
Okay, I would like to, I'm happy to know that the legal system and education in Indonesia, I think we are pretty much the same because we are both under the, maybe I should say, actually there's should I share my screen so that you can see some, let me share my screen. Okay, since we are both under the I think we are under the civil law system. Yeah, so I think we have many similarities between Taiwan and Indonesia. So I think I may focus more about the legal education and system in America. And I will make other comparison between the common law system and civil law system. First of all, I think the education is quite different because in Indonesia and Taiwan, we both have the Bachelor of Degree in law, but in the US, the law degree, the first law degree will be in the graduate school. So those students are maybe at the age of 22 after they receive their bachelor's degree, they go to the law school for 3 years, and we call it the JD degree. So it's quite different from we see in Asia. And can you see the web page from me concerning the legal education? Okay. Yeah. So first of all, this is the overview. So the legal education is quite different from us in Asia. They have the 3 years JD program, but I know that some of the professors from Indonesia and Taiwan, we also have the degree from America. That's because we are in another branch of degree. So let me begin with the JD program. It's a 3-year program. So I know some Asia, like in Japan or in China, they still offer the JD program, but it's not the main, not that commonly seen for many countries. So since in the America, the dominant and the lawmen were mostly they mostly go to JD program for 3 years, and it's very competitive. During my 4 years in the U.S., the GPA is very important, and the professor will grade the students by curve. Maybe only 10% of students can get A+. So it's very competitive for those JD students to earn a good GPA so that they can go to the better law firm and find a better job. So the JD program is for the US, and especially the first year. The GPA in the first year is very important. It could decide how they whether they can receive the better intern opportunity or not. So the first year GPA is always important. And so for the JD program, it's mostly for the American students. So as we Asian, if we study in the US, we don't go to the JD program unless you want to find a job in the US. Like most professors, they are not they were not born in the US, and they don't want to seek a job in the US. They want to go back to teach or go back to be a lawyer. So most professors, when they study in the US, they don't go to the JD program. So it's mostly for the American to learn the law, and it is the first law degree. I know some of the professors have the LLM program. They have the LLM degree. So it falls in the additional programs. The America also provide the LLM program. You can call it the second law degree. So I think I know that many professors, many lecturers from Indonesia, they study LLM. So I think before they go to the US to study the LLM program, they already have a Bachelor of Law like we do in Taiwan. So LLM is mostly for the foreigners to study in the US, but it's also important because when you have an LLM degree, you can take some bar exams in the US, like in California, in New York, or in the state of I think Washington. you can take their bar exam in those states. So it's also very helpful and very beneficial, because you only need to spend 9 months to earn the LLM degree without any thesis. It's not required. So it's very useful and very beneficial, even though it's very very expensive. And so, as you know, there are also professors has the JSD degree, or we call it SAD, like I do. I also take the LLM degree, then I study for another 3 years to pursue the JSD degree in Indiana University. That's why you see the IU, Indiana University, on my profile. And it's mostly for the scholarly training, so we need a dissertation. The dissertation is required. Comparing to the LLM degree, they don't need a thesis, but in SAD or JSD program, we need a dissertation. You might also ask that what's the difference between SAD and PhD? That would be a very good question. As you know that for the SAD, they require 30 credits before you can do the defense. You can make the final oral defense. But for the PhD, they need around 60 credits. That means the tuition fee is doubled, and you need more. I mean, you need to practice teaching, and you need to publish. So it's more profound and demanding degree of the PhD. And it's not a pure law degree in the US, because when you get a PhD in law, you also need to major in criminal law or constitutional law, combined with your law courses. So a PhD degree in the US is not a pure law degree. So they emphasize on the cross subjects learning. So I think that's another difference between SAD and PhD. So most professors only choose the JSD degree because they don't want to teach in the US. But if you have a PhD degree in the US, you have more, and I mean, you have a better chance to teach in the US. Of course, you need to publish. So I think that would be another difference between SAD and PhD. Then we go to the US legal education in comparison. So I think another chart could help, can help us to understand the difference. I think in the US, and let me see. Yeah, we are under the civil law system, so it's different from the common law system, and I think it's good to make some comparison between these two systems. Okay, it has some problem to open that that file, so I can read it for you. So for the common law system, is from England, and for the civil law system is in the Roman Empire. So they are mostly, their origin is different. And second, I know that the common law system is mostly in the English-speaking countries and former British colonies. And for the civil law system is mostly in continental Europe, like Germany. And the other comparison would be the common law system is mostly more adversarial, meaning when you see the court, the two parties against each other, and the judge normally say nothing normally, but in the civil law system, the judge is like a director. They they are in charge of the progress of the court. So it's quite different from these two legal system. And I think the other character would be the common law system is more predictable than adaptable, and the civil law system favors predictability over flexibility. Like we have code, we have a law code to follow, so the judge could know how to do. But in the U.S., they mostly rely on the verdict. They don't rely on the law or the law. So I think that's another difference between these two. And I think that's another difference people may be interested is that in the US, they have two legal system. You can see they have the state court and they have another federal court. That would be quite awkward for us to study in the US when we heard about this. So because we don't have two kind of legal system in our country, but in the US, they have two kind of system of courts. Like they have 3 instances of courts. Even in the state, they have 3 instances, like the state district court, the superior court, and the Supreme Court in the state. And they have another court system in the federal government, even in the state. You can see some federal court in one state, but for the circuit court, one circuit court may be in charge of several states. I think you might be interested, and you might have heard that the circuit court in the US. So you can check it on the map. So you'll see that there's a map showing that how the circuit court governs several states. Like the one I opened, you'll see that for the 7th Circuit Court, it governs the second trial in Indiana, Wisconsin, and Louisiana, and some other states. So the number is the number of circuit courts. This is under the federal system. And for you, for the court, people mostly know about the Supreme Court is in the DC. So there's only one Supreme Court. It's the highest court in the federal court system. So as you see, there are 2 individual different court systems in the U.S. So it's quite awkward for us to know the legal system in the U.S. And for the Supreme Court, I think it can dominate or lead the human right of the global development, like the same-sex marriage or the other human right topics people mostly are interested. I think the Supreme Court will always take the lead. Like Taiwan, we admit the same-sex marriage around 4 to 5 years ago, following US, because we are after 1 year of the US admit the same-sex marriage, maybe in 2018 or 2017, and Taiwan follows the trend of admitting this legal system, maybe in 2018 or 2019. So we can say that the Supreme Court takes the lead of human rights globally. So it's worth noticing that how, like the abortion law, people may mostly concerned about the abortion right in the US because it can affect the global trend of human right development. So I think that's why I would like to introduce the court system in the US, so you'll know that how it could not only affect the whole US territory, but also the whole, global trend of human rights. It will be very influential to us. So I think that's what I can introduce to you about the legal education and the legal system in America and Taiwan. I think one less important factor is I think that in Indonesia and Taiwan, we are very similar. And our law school train our students to be a good judge because they always learn what's fairness, what's the how to do the justice fairly. But you may not know that in the US, they mostly train their students to be a good lawyer, how to stand in the best interest for their client. It's quite different from what we learned in Asia in the civil law system. So I think the angle is different. In the US, they train lawyers, and in Taiwan or in Asia, in Indonesia, we train students to be a good judge, even though they may not be a judge. But first of all, the law school, the foundation lies in fairness. So they don't initially learn how to stand, how to earn the best interest for their client, but they learn how to be fair, how the justice is all about. I think that's what we see in our law school in Asia. I think that would be quite different, and the value is different. So I think that would be a profound impact for the students, for their further development of legal practitioner. So I think that's what I can introduce to you generally. So maybe other professors could make some compliment. I also know that Professor Matias, he teaches legal law in law school for many years. So maybe Matias or other professors, since we are both influenced by the U.S. law sometimes, and I'm also interested to know that I know that the Islamic law in Indonesia has deep influence in the law. I also know that Indonesia has been colonized by Japan, like Taiwan do. We were colonized by Japan for 50 years. So the legal system in Taiwan are deeply influenced by Japan. But I didn't see that any influence or color of Japanese law in Indonesia. Maybe the expert or the professors in Indonesia can explain to us that how the Japan or the Dutch, how they influence your legal system, and maybe the U.S. legal system. Could that be some important part in your legal education or legal system in Indonesia? I think that would be for a Taiwanese interested to know about these areas. Yeah. So could I get back to the mediator so we can have a wonderful discussion?
Okay, thank you so much, Prof. Actually, this quite interesting issue to be discussed, and I'm pretty sure that my student and all participants have questions regarding the legal educations in the U.S. and also the how to say the courts situations in the U.S. But unfortunately, for the Q&A sessions, we will open and at the last agenda. So thank you so much, Prof. James. And without further ado, we jump to the next agenda. The third speaker will be delivered by Prof. Matias. He will discuss on legal system in German. Prof. Matthias, are you there? Hello, Prof.
Yes, can you hear me?
Yeah. Okay. Yeah.
Yes, and can you see my screen?
Yeah.
Okay.
Okay. Time is yours, Prof.
So then. Okay. Well, first of all, thanks for having me today for the invitation and for the introduction. So I want to talk a little bit about the legal system of Germany. So to make basically a SWIFT from Asia to Europe. Actually explain it a little bit deeper. Actually, it's quite complex because there are a lot of layers of law, but I try to decipher that today in my presentation. Of course, if you have questions, please keep them for the Q&A. Of course, I cannot touch everything in these presentation, but of course, I always welcome questions. Okay, so first of all, I want to give you a little quick walkthrough what I want to do today. So what I want to talk about today. So that's basically, first of all, we have already heard a lot of traditions, different kind of legal systems, and legal traditions in the world, notably the civil law traditions, the common law traditions. Of course, it's clear, it has already been mentioned here that Germany belongs to the civil law tradition, albeit it's necessary to say that not everything in Germany is purely civil law. But of course, we also have our own, to some extent, also our own portion of native German or Germanic laws within our legal DNA. So that will be touched in the first section. Then I want to make a big hop in time to the contemporary situation. So basically, as Germany is a belongs to the civil law tradition, of course, its basis, the basic and paramount source of law is, of course, written law, is statute law. So that's why I want to briefly touch on the legislative process in Germany. So actually, as we see, Germany also is, of course, a federal state. So we do not have only one lawmaker, but actually we have several lawmakers beyond the federal level. Of course, we also have the states, or as we call them in German, the Bundesländer. And also, of course, on the local area, they also have, to some extent, been granted legal authority under the Constitution to make these local laws, and which is not mentioned, but which is, of course, also of paramount importance and impact in Germany, is the influence of European law, of EU law, because actually a lot of what seems to be German law on its surface, actually the content is basically European law. So with that, of course, yes, this is also my point number 3. So the role and importance of EU laws, and it's basically to show what different sources of EU law we have that actually impact the national legal systems of the member states, not only Germany, but of course also Germany among them. So what different types and sources of EU law we have and how they actually are being implemented and enforced. This brings me to the next point, law enforcement. So from making laws to actually implementing laws to enforcing laws. This is basically Germany-centric because, of course, the vast portion of the enforcement happens at the national level. So national level here means both federal and states. and with a certain exception for the role of the European Court of Justice, ECJ, or EuGH as it's called in German, which has also very huge impact on the legal system and the application of laws in Germany. And finally, I want to give a little overview of the legal education in Germany and how it actually tries to match these different requirements. So first of all, but let's start here. Oh, that was the hop to the wrong one. So first of all, let's have a look at Germany and its roots in the civil law tradition. As we see here on the map, so I was that's one that I also use in my classes about legal English. So here, Germany, located in the center of Europe, deeply blue. So of course, clearly indicating it's a civil law system. This is of course true by large, but as I have said, actually, of course, Germany also has integrated its own portion of its national legal heritage into its law. So it's not only basically Roman law. It's partly, notably as regards the civil part, it's partly based on Roman law, but of course not all of that. So with that, actually, just let's hop on the slide. So civil law, for I suppose that most of you, of course, are familiar with that, but nevertheless, a little refresher here. So what we nowadays refer to as civil law or a civil law tradition basically dates back to the laws of the Roman Empire. So as they have been compiled and collected in a codex in about the 5th century, which was already about the time of the collapse of the western part of the Roman Empire. But nevertheless, so these laws, just parts of them statutes, parts of them also basically what we nowadays would be called precedent, or the precedents of Roman courts have survived. And they actually have been over times after their rediscovery in the 11th century have been slowly spreading over the whole basically Western European continent, which of course at that time looked very differently from what we see nowadays. Here on the left-hand side, you see also a second very notable source here, so the so-called canon law, based on the Corpus Juris Canonici. So that's basically the law of the Roman Church. Why was this law of the Roman Church important for forming the civil laws in continental Europe, or also in Germany as we know it today? Well, basically because large parts and large chunks of our civil procedural law are taken from these canon law. So the principles that we are nowadays still employ in civil procedure are borrowed from these early law of the Roman Catholic Church. And you see, of course, which is also known of you with your colonial heritage with the Dutch, that of course the civil law then has spread over times also, as it basically has been exported by the European seafaring European nations when they started for their voyages and conquest of the world in the 16th and 17th centuries. It's also noteworthy to say here that, of course, the civil law, at least partially influenced the common law, so in medieval England. So it's not completely true that they are completely distinct and separate, isolated legal systems. Actually, the civil law also had an influence on that. So here, as I said, and this is something, so when I talk about this, I remember back at my first days in the law school, because really, I don't know how it's actually right now, but actually, so when I was in law school in 1919, of course, there were still classes for Roman law. And of course, professors, both for Roman and for ancient German law. And of course, it was, of course, these were not mandatory classes, but of course, it was at least supposed that you would take one of these classes. And it's still nowadays a tradition at some universities that they require, at least if you want to get a PhD from those faculties, that you need to have basic skills in Latin. Well, actually, these corpus, the civil law, as it's named, it's basically based on these collection of Roman laws that has been compiled in the area of the Roman Emperor Justinian in about the 5th century. And as I said, it was basically consisting of 3 parts: so statutes, contemporary statutes, case law, and even also instructions for future lawyers, law students, on how to use these Roman laws. With the collapse of the Roman Empire in the 5th century, at least of the western part of the Roman Empire in the 5th century, of course, the Roman laws have been, first of all, been forgotten for many centuries. Until in the 11th century, we saw something which was the rediscovery of Roman law, which took place at the University of Bologna in Italy, the so-called glossatores, which were fascinated once they found that, and actually started to first research these old ancient Roman laws, because they found that it has the Roman law had a very high level of abstraction, sophistication, which was at that time rarely to be seen. And so actually they used it as a subject basically for academic instruction in their classes. So the Roman law spread, and of course with these students then later applying the law, of course, for sophisticated problems for which the national local laws at the time did not provide solutions. They often also refer to these solutions from the old Roman law. So this actually led to what has become later been known under the so-called jus commune, which actually sounds very similar. Jus basically is the Latin term for law. Commune just means common. So basically the Latin term for common law. So indeed, actually, the Roman law at that time in Europe, despite of the fact that it has never been formally enacted, has also become a source for legal solutions. But of course, it was subordinate by nature. And this, of course, was also true in Germany for the past centuries. That, of course, Roman law has been referred to as far as, for example, German law. German legal principles did not provide an according solution. This situation changed actually at the beginning of the 18th, 19th century with the so-called codification movement, so the creation of new legal codes. This development was basically triggered by Napoleon with its notable Code Civil, which was published in 1804. And of course, this has been an important role model for the development of the legal systems, not only of Germany, which was very late as regards that, but also of other European nations and countries. Because the idea was basically what the Romans have already achieved 1,300 years earlier, we should also nowadays be able to achieve. So a comprehensive, ordered, structured compilation of the laws. So then actually, also because of the fact that, of course, the French were very dominant at that time, so these Code Civil has actually spread. It has also been directly applied in parts of Germany, in the southern part of Germany, notably because they were under very strong French influence at that time. But overall, Germany, so in the beginning of the 19th century, was not yet a state, not yet a nation in the modern sense, but consisted of a lot of basically small independent territories, each of which basically had its own legal system. But part of them already used also these Code Civil. You then see here Austria followed suit in 1811, and finally Germany, which after almost 20 years of deliberations, they basically made two huge drafts for it. In 1896, promulgated the so-called Bürgerliches Gesetzbuch, or short BGB, which is the civil code of Germany, which then was formally enacted starting from January 1st, 1900. So it's now in force for 125 years, but of course it also has seen a lot of changes since then. And of course, so it also has influenced other similar codifications, like the Swiss Schweizerisches Zivilgesetzbuch, but also, for example, laws like that of Japan, which studied German law very intensively, and also in parts in Taiwan here, where a lot of, at least traditionally, a lot of Taiwanese legal scholars actually got their PhDs from Germany and are very familiar with the German law. Okay, so this being said, so with Germany being a civil, basically a civil law country, of course, what sources of law do we have? So that's first of all and predominantly statutory law, of course. There are codes, notably the traditional huge codes like the civil code, the criminal code, and the according codes of civil and criminal procedure, to name just a few. There is an overwhelming plethora of statutes, in German called Gesetz, and of course also regulations of all sorts. Germany, as regards case law, sometimes if you read that, notably if you saw also treatises written by German scholars in English, then they also refer to case law. Of course, if you read the term in connection with German law, you need to be careful. Case law here is not case law in the sense of common law. In the common law, we know there is the doctrine of stare decisis, so case law is regularly binding on the lower courts. So precedents are binding on lower courts. They should follow what the court and higher court has said earlier. This is not true for German courts. So if some judge at a local court sees it fit to come to a different conclusion, legal conclusion, than the German Supreme Court, then he can do so. This is not a violation because he has not bound by any prior judgment or precedent made by the German Supreme Court. This being said, of course, this is very unusual to happen because in practice, of course, courts do note and do actually take in account what the higher courts say, and typically they follow them unless there are very good reasons to not to do so. Nevertheless, there's one notable exception also for the German law where we really have binding precedents, binding case law, and this regards decisions made by the Federal Constitutional Court because they have been granted explicit statutory power. So under the law about the Federal Constitutional Court, that they can actually, for example, if they avoid a statute, so if they declare a law, a certain statute to be unconstitutional, they can basically set up provisional rules, rules that should be followed, and if they promulgate them according to Article 31 of the Bundesverfassungsgerichtsgesetz, then they basically are binding. They are binding as a statute. But this is the only notable exception. Besides customary law is, of course, recognized, it's acknowledged in German jurisprudence as a further source of law, but it does not really play an important matter or an important role anymore. There has been more in the past, notably in the field of commercial law, as it's got usages, for example, of merchants and things like that. But nowadays, of course, this is not really relevant. There was some notable example every law student need to know until about, so when I studied law until 20 years ago, when the BGB was revised, so the so-called PVV. That means, for example, if you perform wrongly regarding a contractual obligation, so you perform, but your performance is not sufficient, and you create damages to the creditor, then because there was no consensus among the legal scholars that the BGB actually did not deal with that situation, so it was recognized that this could be actually solved by law, which then already got the status of customary law. But this is a very, or this has been a very rare exception. With this being said, so for the general structure of the German legal system, well, there is nothing particularly sophisticated about of that. Of course, overall, there is the constitution here. This is to be said here. I talk about the federal constitutions, of course, because Germany is a federal state. Every state, every Bundesland also has its own constitution. But here the federal constitution, which is a paramount law, and of course, which every subordinate law, ordinary law, statute, code, or regulation needs to be in compliance with. If not, they are unconstitutional and they can be declared void. Besides that, we see different from the US system, we see the typical situation between here private law, criminal law, and public or administrative law. In this regard, it's noteworthy to say that here the private and the criminal law are basically dominated by federal statutes or federal codes. Also regarding the associated procedural laws. Whereas administrative law is basically a mix. Administrative law is to some parts federal law, to some parts actually it's also state law. So, a little bit about the legislature, the legislative process in Germany. I only want to highlight here some key points. First of all, here from the German Constitution, the so-called Grundgesetz, Article 20, as it says, the Federal Republic of Germany is a democratic and social federal state. The legislature shall be bound by the constitutional order, the executive and the judiciary by law and justice. So this brings us as conclusions basically three paramount principles, fundamental principles, which govern the legal system here. That's first of all people's sovereignty as regards the part of the lawmaker. So basically all these lawmaking power is derived from the people, which is exercised in parliament. So German does not know, the German constitution, the federal constitution does not provide for any plebiscite elements. So there are not, the German federal constitution does not provide, for example, for the possibility to have a people's referendum on legal issues, on legal questions. So this is after the bad experience with the Nazi area, the founders of the constitution, the fathers of the constitution were very skeptical and very cautious regarding giving too much power to the people themselves. So they said they should exercise these powers only through the elected representatives in parliament. Of course, federalism has been dominating the German history for centuries. So basically, German has been, as I said, so Germany, as we know in its modern form, it's basically just 150 years old. So it was founded, the German Empire, the predecessor of the Bundesrepublik Deutschland, has been united of these German-speaking territories in 1870. And this is basically where also the traditions of the huge codification start, with some time lap in between. As regards the constitutional history of Germany, there was one notable predecessor of the modern constitution, that was the so-called Weimar Constitution of 1918, which a lot of elements have been also used in Germany's present constitution, but basically that the system of government has been changed. So we have changed from a presidential to a parliamentary system because of our bad experiences in history with the misuse of presidential powers. So this being said, here, if you see the outline, so basically Germany had 3 tiers of government. It means also 3 tiers of legislation, of legislative input. So there's the federal level, there is the so-called state level, as it's called here, federal states. Or as we call them in German, the Bundesländer here. It's noteworthy that the Bundesländer also include here 3 cities, so Hamburg, Bremen, and Berlin, which are given basically the same status as a federal area state, but which are in fact are just huge cities. And then, of course, here all these levels of local government in several also subdivisions, which we do not do more closely observe here at the moment. So here you see on the map, that's the separation here of the Germany into these different Bundesländer, into these different states. So as you know, Germany was reunified in 1919. Before it has been 11 originally. Then it was later on amended by 5 new states in the east. So at the moment it's 16, and that's the final status. So, of course, the Constitution also provides that not only the federal Constitution must adhere to these principles, which we have just mentioned: people's sovereignty, rule of law, and social welfare state, but these principles are also prescribed in the federal constitution to be implemented by the federal states. So if a federal state wants to change its own constitution and, for example, he would limit the opportunities for people's representations, then this would be also a violation of the federal constitution. So the federal legislature, very short in Germany. So you see here on the left side, in Germany, it's bicameral. That means it has two chambers. First of all, the main chamber is here, the Bundestag. So from which you see the picture here on the left-hand side. And the second one is the Bundesrat. Bundesrat is basically the representation or the assembly of the representatives of the foreign states, so that they of the foreign states of the Bundesländer, so that they also have an opportunity to influence federal legislation. But actually, so of course here the main actor is the Bundestag. The the Bundestag actually is the only chamber of the parliament which is directly elected by the people. Different from the Bundesrat, because in the Bundesrat actually you also only have representatives which are sent by the Bundesländer, by the states, and only selected by the governments of these states, not by the state parliament. So that's a different system. So besides legislation, making legislation, which is of course their paramount task, they also have determined the chancellor, which is the basically German federal prime minister, the head of the government. So in its form, the German system of government is somewhat similar to the British one. So the head of government typically needs to be carried by a stable and large majority in the parliament, which also because further constitutional precautions in Germany in the past, we had typically very stable political majorities. At the moment, the situation is a little bit shifting. And because we see also a lot of new parties emerge, relatively new phenomenon, but for the major part of the past, it's true that you say we had a lot of times with very stable legislative majorities. So as regards the legislative power in Germany is basically distributed between the federal level and the state level. And basically we have can distinguish three different forms. There is basically exclusively federal matters, for example, like things as defense or foreign affairs. It's immigration, citizenship. Of course, it's dominated basically by the subject matter itself. There is exclusively state matters, in which the federal government can say actually nothing. Even if they want to. The basic principle under the German constitution is here in Article 30, except as otherwise provided or permitted by this constitution, the exercise of state powers and the discharge of state function is a matter for the Länder. This is also not only true for the administration, but also for the legislation. And basically it means at points where the constitution is silent, the legislative competency, the legislative authority automatically belongs to the states and not to the federal level. However, the federal level could change that, but if they want to change it, they need to change the federal constitution, which requires a 2/3 quorum. very interesting form is the so-called concurrent legislative power, which is basically a form of shared legislative power between the federal and the state level. To demonstrate that, actually, I will quote here from Article 72. That's the pertinent article in German Constitution. Which says here on concurrent legislative powers, on matters within the concurrent legislative power, the Länder, so that's the states, shall have power to legislate so long as and to the extent that the federal level, the federation, has not exercised its legislative power by enacting a law. Yeah. So that means, of course, clearly that here, for example, the federal legislator, which is also bound here by Article 72, because he cannot automatically say if it's a matter of concurrent legislative powers that I basically provide for an complete and 100% complete rules. So I do not leave anything left to the Bundesländer. But basically, the federal level can only do so if it's necessary to establish equivalent living conditions throughout Germany. This is also a legal requirement which is checked, for example, if that particular statute is challenged in the Federal Constitutional Court. So of course, even so, if this requirement is not satisfied, or if the federal level says, okay, certain questions basically we leave into the discretion of the state lawmakers, then they can do so. So they can stipulate that this the laws the states actually can provide additional laws, complementary laws, for example, for certain questions which fall in these concurrent legislative power, even if the federal level also already has enacted an own law. To give you an example for this is, for example, the civil law, civil code in Germany. A very comprehensive code, but for example, as you see, so in the introductory act of the civil code, that's basically the implementing act of the civil code. It says here, insofar as in the civil code or in this act, the regulation is reserved for the statutes of a land, or insofar as it's ordered that the provisions of the law of a land remain unaffected or can be decreed, the existing provisions of the law of the land will continue to be enforced, and the land can also decree new statutory provisions. So old law can persist, can continue, new law can even be also created if these authority is given under concurrent legislative powers. One example here is Bavaria, a state in the south of Germany, for example, about certain aspects, private law aspects of neighboring law, which are here, as you see in this excerpt, provided by national law. That's not only true for substantive law, but also for procedural law, because here that's another part from Baden-Württemberg, so that's my home state. Here, where also certain portions of criminal procedures can be added, can be amended by specific provisions, and also different provisions, of course, potentially from the states. This being said, so this possibility exists, but nevertheless, of course, it's also true that basically speaking, notably in the large fields of law, private law, so civil law, criminal law, these are largely dominated by federal law. So these examples which I've shown you here, they exist, but they are limited or rather to very to smaller aspects of the law. Okay, a little bit shortly, very briefly about the hierarchies of law. Well, so because first of all, you need to make sure then if you have different levels of law, well, what you expect here and also expressed in Article 31 of the German Constitution, so the supremacy of federal law shall take precedence the land law, the law of the Bundesländer, this clause is often misunderstood. This does not say that every federal law automatically prevails over state law. This only means, of course, that only constitutional federal law prevails over the state law. So, for example, if the federal level has neglected or has infringed, exceeded its legislative authority, so that the federal law is unconstitutional and could be voided, then of course this point here does not apply. Okay, so now here to a very important part also, as I've mentioned before, so the role and importance of European Union law. So Germany is part of the European Union. So what is the European Union? Of course, I suppose that I don't need to explain that. It's not a state, so it's not a federal structure, but it's also not. But actually, it's more than a international organization. So for this type of laws, actually, we refer to in Germany that the EU law has a kind of supranational effect. Means it's directly binding regularly, and also it supersedes national laws in all the EU member states, despite of the fact that the EU itself is not a country and it's not a state. As regards here, so this chart is basically showing the interaction between the national German level and the European institutions. I want just to highlight 2 points here. These are what we have here in these rectangles. So these are 2 notable instruments of secondary EU legislations. This is first of all a Richtlinie, that's the German term. That's what we know as a so-called directive, EU directive, and Verordnungen, that's the so-called EU regulation. That's the 2 notable pieces of EU law which have an very important influence on the national laws in the member states. Regardless of their nature, most of them are actually, or they are produced basically, typically upon an initiative, normally from the European Commission, and then in the past, basically being dominated by the EU Council. That's basically the assembly of the ministers or heads of government of the EU member states, and this is increasingly now in the modern situation, also in collaboration with the EU Parliament. So they basically collaborate on these lawmaking process, but with a preponderance here still on the EU Council. And they have these 2 instruments which in order to create laws. So what types of EU laws do we have? Well, first of all, there's the so-called EU primary law. The EU primary law is basically the law that we have in the EU treaties, notably the 4 which you see here on this slide. So the Treaty on the European Union, the Treaty on the Functioning of the European Union. So the naming also has changed a little bit about the past, and also the Charter of the Fundamental Rights of the European Union, basically like the Basic Rights Charter of the European Union. This is the so-called primary law, EU primary law, which is binding on all EU member states. It has automatically precedence over all EU secondary law and also over all national law, even in principle at least, also over national constitutional laws of the respective EU members. And depending on its nature, it might be directly enforceable and also applicable. I will show you an example in a minute. Second, there are the so-called EU regulations. EU regulations are the preferred means of legal harmonization in the EU. In the EU area, this is typically, that's wrong, that's for the EU directive. EU regulations are basically directly enforceable law in all the EU member states. So they can be and must be directly applied by all national institutions and authorities, national courts, national administrative authorities, and so on. And they also have precedence over national law. Then coming to the third point here, the EU directives. The EU directives play a very huge role because they are the preferred means of harmonization, of legal harmonization throughout the European Union. Actually, here they are basically addressed towards the national lawmakers. So they are normally not directly applicable. So, for example, you cannot, as in a lawsuit, you cannot directly claim, for example, rights from such an EU directive because they first need to be implemented. The idea is that, notably because in the EU area, we used to have different legal traditions, also common law traditions with the UK, which has already left, but also Ireland. So that is, of course, sometimes not very useful that you make a directly applicable EU regulation, but that you rather say, we leave it up to the national lawmakers where it fits in best into the national legal system. But nevertheless, at the end, they need to comply with it. If they don't do so, that's a violation of EU primary law, of the obligations of the member states under the EU treaties, for which they can be severely punished. And also to some extent, then maybe, so once the term for implementation is already overdue, actually there might be also a direct recourse possible onto rights that are granted in EU directives. So just to give you some examples, for example, EU antitrust law is directly stipulated here in the EU primary law, here in Article 101. It has changed its numbering a couple of times. Now it's 101. So this is directly applicable. What's that? That's not what I wanted. As you see, any agreements or decisions prohibited pursuant to shall be automatically void. So this is needs to be observed, despite of the fact that it is EU primary law. So that's an example for EU primary law, which could be directly used, or which must be directly used and followed also in national legal proceedings, which is not only addressed versus the national lawmakers. Besides, here regards these regulations, so huge portions of the conflicts of law rules or the international private law. So, for example, what law should apply if I have a closer contract with a merchant from Indonesia? Is it Indonesian law? Is it German law? Is it any other law? So if a German court has to decide about that, which law to apply, then the rules here, these conflict of law rules, are basically provided for in these EU regulations, for example. It's just one example. Another notable example would be, for example, the EU trademark regulation. Actually providing for a unified EU trademark, which stands next to and in parallel to the national trademark systems. Finally, last example here, the EU IP Enforcement Directive. This is also notable in the field of IP law. So this is basically something every member state needs to implement, but they basically implement this into their own national law. So at the surface, it seems to be a German law, or it seems to be in a couple of German laws, but underlying it's basically European law. And this is necessary to note because also the European Court of Justice can rule on the interpretation of these rules. So what about the time? Yes, okay, I hurry a little bit up. So regarding the law enforcement in Germany, a slightly shocking diagram for you. here, as you see. So this is basically the German court structure. So really, don't be surprised about it. It's really that complex. What is noteworthy, what I want to say, so unlike, for example, the legal system in the United States, where we have separate, completely independent judiciaries. So we have a full-grown state judiciary and we have a full-grown federal judiciary. In Germany, it's a little bit different because basically the first two levels of courts, so the trial court level and the intermediate appellate court levels, are state courts, and only the upper appellate court level, so they are federal courts. So they basically only what you have here in this blue frame here. They basically only hear appeals on issues of law. They do not deal with finding facts. They basically only apply, do a legal review, whether there was made a mistake in the lower instances. As we see altogether in Germany, we have basically 5 branches. So civil matters, criminal matters, there is one for the administrative courts. This is financial matters. It's basically financial administrative law, tax law, basically. There is one for here labor law matters, so a special type of civil law disputes. And of course, here for social welfare matters, also special type of administrative litigation. So as you see, basically the structure is 3-tiered: trial courts, intermediate appellate courts, and final appellate courts for legal review. With the exception here of the Finanzgerichte, these tax courts, which is only 2 instances, and here also the civil and the criminal courts, where you basically have the burden shifted. You have a further instance, but also here the instance sequence is only also 3-tiered. Okay. Finally, a word about the role of the European Court of Justice. The European Court of Justice, of course, plays a very important role in the implementation of EU laws. Why that? So, of course, guess what the situation would be if the EU could only make, for example, directives which they address to the member states, but basically they would have no control about the enforcement or the interpretation. So they would not be enforced at all. Maybe every member state would come to different conclusions. So for this purpose, there is a special kind of proceeding, which is often provided for in Article 267 of the Treaty about the European Union. And these are these so-called preliminary ruling proceedings. Basically, it says if a court stumbles about an issue of law which is crucial for the decision of the pending lawsuit, and this issue of law is connected to European law. So, for example, because it's directly like Article 101 of the EC treaty, so this antitrust provision, or, for example, also in national trademark law, which is based on an EU regulation. So in either of those cases, if there's a question about the interpretation, the national courts can send the files to the European Court of Justice and asking for a binding interpretation of the European portion of the legal issue. The European Court of Justice does not decide the whole lawsuit. They only decide about these interpretation of the pertinent European laws. But of course, this plays a huge role because, for example, also in IP law, in consumer laws, because most of them have a strong basis nowadays in pertinent EU directives, for example. So here the role of the European Court of Justice is pivotal for the functioning of the legal system also in Germany. So last but not least, very short, a little bit about the legal education in Germany. Actually, as James already has mentioned here, so that notably it's true for Taiwan. So the education is focused on the ideal of deciding from the perspective of a judge. This is also basically an approach that is taken in German legal education. Also, Germany differs from Taiwan regarding the fact that we foster the idea, the role model of a so-called Einheitsjurist. So you could also say a one-size-fits-it-all approach. So basically, the idea is with going through these course of legal education and successfully passing these two legal exams, then you're basically qualified for whatever higher legal profession, regardless whether that's a judge, regardless whether that's a lawyer, or regardless whether that's a higher administrative officer. This does not mean say that so once you have passed these exams that you're automatically accepted, because you will also be graded, and of course the selection also takes place based on largely based on your grades. But basically saying, so once you have passed these two exams, you are a full qualified lawyer with what we say it in German, or how we say it in German, the Befähigung zum Richteramt. That means you're able to be a judge. So in practice, that means it's basically two stages. So first of all, there's of course the stage at the university. That's nowadays 4 to 5 years. In the past, it has been partly much longer, basically due to the fact that the exams are very selective, are very competitive and very selective. They have typically a high failing rates of more than a third, or only the third is only those who fail at the final exam, not those who already drop out earlier. So I remember the speech of my dean from the beginning when I was freshman in law school, which said at the very end of his speech said, okay, so now turn your heads left and then turn it right. I promise you by the end of your studies here at our university, that your two neighbors probably will be gone. And that's really still holds true. So this period actually ends with a state exam. State exam means it's administered by the state, so there is not a university exam administered by the university, but basically every Bundesland holds these exams for all the legal departments in its area. So it's completely comparable. And afterwards, you have 2 years of judicial training. That's really training on the job. So you're basically working in a civil court as a judge's assistant, in the prosecutor's office, as an attorney at law, in an administrative authority, all through these stages. And then you have another exam. And once you have passed them, then you basically are a fully qualified lawyer. This being said, these exams are administered at the state level. So basically, of course, every Bundesland has its own examining authority for this. But of course, they are recognized completely throughout Germany. That means, for example, regardless whether you do your exams in Bavaria or whether you do them in Schleswig-Holstein, they will be recognized also elsewhere. So that's very roughly the situation. So of course, there could be much more added here, but I see we already run a little bit overdue with time. So I want to conclude my presentation here. Thanks for your patience and also for your attention. Hope there was at least something new for you and interesting. And then, of course, I'm happy to answer any questions, if any. Thank you.
Yeah, thank you very much for the presentation, Prof. Matthias. It's quite interesting issue. Okay, finally we got we already arrived to the last agenda, that is Q&A sessions. So actually, Prof, we have offline and online participants. So we just open one question for the offline participants and another question from online participants. Okay.
Okay.
If there is any questions here, maybe for the offline participants. Yeah, Vanessa. Okay, time is yours. Can you open your microphone?
First of all, I would like to thank to the speaker and the moderator. And I have two questions for this time. And the first question I want to give the question firstly with Mr. Jamshu. And the question is, international interaction of society is happening. We cannot deny it. How your opinion about the international law, the comparing with national legal system? Is it rival or other? Maybe the first question is it, and I wanna give the second question with Mr. Matis. The question is, what do you think about the marriage with the same sex? One side is the human right, but an other side is helping with the population while population is state needs. Maybe the question like that. Thank you.
Okay. Yeah. Maybe we just drive to the answer sessions and then we jump to the next questions. So there is two questions for the Prof. James and Prof. Matthias. Maybe we start from the first questions for Prof. James.
Okay.
Prof. James?
I think it's about international law, but I'm not quite connected. What's the issue about international law that she mentioned? Yeah, I can you rephrase her question about international law?
Okay, the question is, international interaction of society is happening. How we can not deny it? How your opinion about the international law, the comparing with national legal system? Is it rival or others? Thank you.
Yeah. Can you rephrase her question because I not quite follow the question.
Okay, maybe I can help for the questions. What the question is? Okay, Prof. Actually, the questions is regarding to the international law and national law. When actually every state have a national law and we have also international law, and when have some legal issue in international relations maybe, or any activity that happen cross border to the countries. So the questions like how we it's like when international apply and why when the national law applied for the cases actually.
Yeah, I see. I think that would depend on the international treaty or convention. They might make some agreement like what we do in WTO or in some kind of UN. We need to have some diplomatic agreement with other countries, because if it's out of your jurisdiction, you cannot do anything about it. So I think that would be mostly relied on the diplomatic strategy or agreement with other countries. Like someone committed crime in Indonesia, if we don't have a relation tie between Taiwan and Indonesia, it may be hard to have those criminals have them sent back to Taiwan, or so I think if it's out of the jurisdiction of one nation, it would be hard, mostly relied on the diplomatic relation or agreement. That's what I know.
Okay, thanks for the answer, Prof. For the next questions, it's for Prof. Matthias.
Yes, so it's about
Same-sex marriage, Prof.
the same-sex marriage in Germany. Yes, well, I'm not a particular expert about that, but at least I have an opinion about that. So, well, first of all, so Germany, so that the status is that Germany in the early 2000 years, actually, because of the then central to left-wing government, actually had pushed to liberalize these same-sex marriages as part of a larger reform agenda on societal issues. So because of course they also have a strong voter basis there. There was a huge discussion in Germany against the backdrop of German constitutional law, notably because also the German constitution puts particular emphasis on protection of not only marriage, but also family. And the question actually was here also whether these protection, first of all, what means then the protection of marriage in the constitutional context, as we have in the language of the Constitution. If you start from an historic perspective, well, definitely at the time the Constitution was written, it was clearly the idea of a heterosexual relationships, or not of same-sex marriages. But of course, this would only be one argument. But the question also was that it says basically marriages were under constitutional protection in connection, it needs to be read in connection with the protection for families, so parents plus children. And this basically was, at least by some, interpreted to be in the sense that it means, okay, so children basically can only be produced as the basis for every society by out of a heterosexual relationship, marriage, so that basically it's questionable why you should whether you really could actually give also the same rights to same-sex relationships. So there was a huge debate about it. Of course, it was basically against the backdrop of different basically political views and moral views on these issues, but of course they also were underpinned with these legal argument. I think there has been in Germany, of course, several rulings from the federal Supreme Court, because the German government at that time was then so once these has started, they were very reluctant to implement these laws. So German was a little bit behind the general trend in Western countries. here, but basically, indeed, the German government has been largely pushed by the Constitutional Court. Also, not only to make was not only the question to make same-sex marriages possible. By the way, in German we deliberately use different terms. So the term for marriage is Ehe, but actually the term for same-sex marriage is Partnerschaft, so partnership. So it was also one of the reasons that you say we do not use the same term for this to distinguish it. And it was also means, or at least in the beginning, that mean that it was completed completely equally. But actually the government has been pushed here by the Constitutional Court to do this. As I said, so my specific focus is on IP law. So I'm afraid, but I regret that I need to admit that I'm of course largely know the arguments, but of course I'm no expert on these specific details of constitutional law. But maybe this might be sufficient as an explanation.
Okay, thank you, Prof. Actually, for your information, why my student asked about the same-sex marriage, because some of Indonesian, if they want to do same-sex marriage, they just go to German. And for your information, there is Indonesian people that do same-sex marriage and become celebrity of that, because do same-sex marriage, he becomes celebrity now. So my student asked the questions like that. Okay, for the next questions, maybe we open 2 questions for the online participants. Just raise your hand and open your microphone.
Excuse me, sir.
Okay, Rahmat. Yeah, time is yours.
This question for Mr. Dr. Irwansyah, SHLLM. So, first of all, let me introduce myself. My name is Rahmat Alfian Hidayat. I'm a student from the Faculty of Law, Muhammadiyah University, Kendari. So the question is, some time ago, Indonesia combined 2 laws into one, called Omnibus Law. This law is considered by some experts to be incompatible with Indonesia's existing legal system, which is civil law. So, sir, what is your opinion on the Omnibus Law? Do you think this is a new breakthrough for Indonesia's legal system, or just a misunderstanding of Indonesia's legal system? Thank you.
Do you have another questions?
No, sir, just
Okay.
that's all.
Okay,
Thank you.
Prof. Pak Irwansyah, time is yours.
Well, thank you very much for the question, Mr. Rahmat. Of course, this is the new thing that I have to answer about the Omnibus Law is existing as a legal system of Indonesia. The first thing, this is new thing in our regulation, that when the executive members, in this case, a president and the legislative member of Indonesia, collaborate to do the Omnibus Law. While I think there are many contradictions why the Omnibus Law is existing in Indonesia now, because there are several ordinance or regulations and contradictive between the other regulation with the one regulation with the other regulation. Because of that, this is the second for the second regulation, the second act we ever do the how to unite the regulation that regulate the same thing. For example, in about the general election. For several years ago, presidential election has the Awan Act, and of course also about the legislative member and regional legislative also has the Awan's regulation. So now it's united into one thing, omnibus law, and about the general election and number 7 2017. Now you can see from that, I think this is a good thing for Indonesia because if we implement the omnibus law system, of course that's easy for us to research to see what regulation about the society and the government for exactly. For example, about the trading and money laundering and so on and so forth. For the future, I support our country to implement the omnibus law for several things that have the same how to say correlation between one regulation to the other regulation. So this is a new thing. For example, also about the regulation about the Islamic law. We cannot deny that's happened now. There are several regulations about heritage, about marriage, and so on and so far. So for the future, maybe the regional courts can unite all the subject in one thing in omnibus law. I think that's my question for Mr. Rahmat. Thank you.
Okay, thanks very much for the answer. And the last questions, maybe we just open for the last questions. Oh, Syarif Hidayatullah. Yeah, time is yours.
Well, thank you so much, from Moderate, for giving me opportunity to be a part of this great discussion today. My question to Prof. Matthias. The topic about federal legislature. That my question is, what is the position and legislative function of the Bundesrat as the highest assembly in the Germany? The second question is, there is a unique rule in Germany that we are called affiliation if we use the word du or do and C or SIE in front of the place. So my question is, what is your view regarding freedom of expression in Germany, Prof? That's it.
Okay, Brother Syarif have two questions for Matthias. Okay, you can answer. Okay, time is yours. Actually, you didn't open your microphone.
So can you hear me?
Yeah.
So, yes. So the first question, as regards the role of the Bundesrat in the federal system, the federal legislation. So, as I said, so the German system is basically bicameral. So that means we have the main chamber, that's the Bundestag, and the Bundesrat. The Bundesrat here has the function that it basically should give a forum, provide a forum for the Länder to participate in the federal lawmaking process. The idea is that because it's also linked to the German system of government, because the German federal constitution provides basically more legislative authorities to the federal level, whereas basically provides more executive authorities to the levels of the Bundesländer. And this includes also that the Bundesländer actually they do not only need to implement these federal laws, but actually, for example, they also need to decide to set up which kind of administrative authorities they need to set up, what kind of administrative procedures for this, and of course also they need to do the funding for these tasks. So that means the federal level can basically create new obligations, can create new tasks and duties, which then need to be executed by the Bundesländer. And for this purpose, of course, it's mandatory, it's necessary that there is a forum for participation for the Bundesländer. Basically, the role of the Bundesrat is split. Depends on the type of law. There's sometimes some cases or some types of legislations which are so-called Zustimmungsgesetze in German. It means basically the Bundesrat needs to give its assent. If it does not give its assent, if it does not agree with that, then basically the legislation process will fail. So the bill will cannot be enacted. In other types of laws are so-called Einspruchsgesetze. So basically, the Bundesrat can only veto these bills from the Bundestag. But this veto actually can be overruled by an according second vote in the Bundestag. So in the German parliamentary practice, actually, there is also a third institution which is not mentioned and only very scarcely mentioned in the German constitution. This is the Vermittlungsausschuss. Basically, a lot of these laws then, so in controversial situations, you can have controversial situations because the majority changes. Maybe, for example, you have a CDU majority, a conservative majority at the federal level, but then because of several elections at the Bundesländer, then maybe the social, central social left-wing parties gain a majority. So then they will try, for example, to oppose the federal politics by using their influence in the Bundesrat. Typically, this is solved by means of negotiations, by making according compromises. So at least this was the model in the past. And the Bundesrat, as I mentioned, is not only actually, it's not sort of representatives that are sent to the Bundesrat are determined by the Bundesländer, by the governments of the Bundesländer. They are not determined by the people directly. They are not determined by the people in this Bundesland, but only by the government of this Bundesland, which is basically due to the specific role which they and function which they have. Okay, so that's for your question. And what was the second question? Sorry, I need to ask again. I forgot.
Sharif?
What was the second question?
Can you repeat the second question, please? Muhammad Sharif. Yeah.
Hello? Can you hear
Can you
my
repeat the
voice?
second question, please?
Yeah, I'm sorry. I will repeat my question. I mean, I have read before in article that there is a unique rule in Germany that we are call it evaluation if you use the word do and see in front of the police. So my question is, what is your view regarding freedom of expression in Germany, sir? That's it, sir. Thank you.
That's a very general question. I'm sorry, I do not. I'm afraid I do not precisely get what was the first part of your explanation. What was the statement in this specific article? As regards the freedom of expression in Germany and the freedom of opinion. Well, of course, also I'm no constitutional expert, but of course it's also guaranteed largely, and there's a plethora of actually case law by the Federal Constitutional Court. So I'm not particularly afraid of the status of freedom of expression in Germany. I think the state is quite well.
Thank you, sir.
Okay, because we have no time anymore actually. Yeah, I will say thank you for the all presenters and all participants that make this agenda happen. And I hope we can do this agenda annually, Prof. Matthias and Prof. James. And once again, I say thanks for your participations and the great presentations. Yeah, maybe that's all from me. We can end this agenda by reciting Alhamdulillah bersama-sama. Alhamdulillahirrabbilalamin. Selamat Prof. Matthias and Prof. James.
Yes, thank you very much. Also, thank you very much for the invitation. I'm always happy to share my experience and to learn about new things, notably from Indonesia. Wahoody knows, of course, we had several Indonesian students here in Asia University. I still have very good memories of all of them. So.
Yeah.
Yeah.
Thank you,
Yeah.
Prof. James and Prof. Matthias.
Yeah. Okay. See you.
Thank you. Thank you.
Thank you so much.
Yo. Bye-bye.
Bye-bye.
Auf Wiedersehen.
Auf Wiedersehen. Tschüss.